There is a woman named Dorothy. She is 71 years old. She lives alone in a house she has owned for 34 years on a rural road where the nearest neighbor is a quarter-mile away. Her husband died 3 years ago. She has a legally registered firearm in that home, has had it for over 2 decades. She keeps it in her nightstand, not because she is paranoid, not because she is dangerous, because she is a responsible, independent American woman who decided long ago that her safety was her own responsibility. And she acted on that decision the way law-abiding citizens do. Legally, deliberately, consistently. Then her state passed a new set of gun laws, and her daughter called her and said, "Mom, I think you have to give up the gun." And Dorothy almost did. Almost. Because what nobody told Dorothy, not the news channel that covered the new law, not the local police department, not even her well-meaning daughter, was that every single new requirement in that law had a specific legal exemption that applied directly to her. Every single one. And this is not a story about Dorothy. This is a story about what is happening to senior gun owners across this country right now in 2026, and why the people responsible for informing them are failing catastrophically and consistently to do their jobs. If this topic matters to you, if you have a parent, a grandparent, an aunt or uncle who owns a firearm legally and is scared right now, subscribe to this channel before you do anything else, because this is exactly the kind of reporting that mainstream outlets refuse to do, and the people who need this information are not going to find it by accident. Let me tell you what is actually happening out there. In the past several years, state after state has passed new gun-carrying legislation, new permit structures, mandatory training requirements, requalification timelines, increased fees, age-based capacity restrictions. The legislative wave is real. It is documented, and in many cases, it is legal. But here's the part that is not being reported. Every single time one of these laws passes, the coverage follows the exact same template. Here's what changed. Here is what you now must do. Here's the deadline. And then it ends. That is the story. That is the full picture the American media is choosing to give you, what is almost never included. What I have watched get left out, time after time, state after state, outlet after outlet, is this. Here is who is specifically exempt. Here is who does not have to comply. Here is who the legislature itself carved out of these requirements. And seniors are being crushed by that omission in ways that are not accidental, even when they are not intentional. Think carefully about who is most vulnerable to a misinformation gap on something like this. It is not a 30-year-old with a lawyer friend in his phone contacts. It is not a 45-year-old with the time, the digital literacy, and the institutional confidence to dig through legislative databases. It is a 70-year-old woman sitting alone in a farmhouse who trusts what she hears on the television, who believes her daughter when her daughter sounds worried, who does not want to accidentally break a law she does not fully understand, and who would rather give something up than risk being on the wrong side of a government she has respected her entire life. That is the demographic being failed here. That is who falls through the gap between what the law says and what people are being told the law says. And in that gap, thousands of legally owned firearms are being surrendered by people who had every legal right to keep them, people who are never going to get them back, people who are now less safe in their own homes because of a failure of information, not a failure of law. I want to be absolutely clear about something before we go any further. I am not telling you that every new gun law is wrong. I am not telling you that legislators who pass new requirements have malicious intent. What I'm telling you is that the consistent failure to communicate legal exemptions to the people most affected by them is a pattern. It is documentable, and when that pattern consistently results in senior citizens voluntarily surrendering legal property based on misinformation, the consequences are real, they are irreversible, and somebody needs to be talking about it loudly and directly. That is what this is. Now let us get into the specifics, because the law's on your side, and it is time you knew exactly how. The first protection that most senior gun owners have never been told about is this. Many states that have passed new carrying permit requirements have written directly into those laws an exemption for gun owners above a certain age, typically 65 or older, who have held a valid permit for a continuous period of years. In those states, those seniors are not required to requalify, retest, or pay new fees to maintain their carry rights under the new law structure. This is not rumor. This is not a legal gray area. This is written into the statutes of multiple states right now, today, in 2026. And the reason it exists tells you something important about how the law actually thinks about this issue. When a legislature passes a new gun law that imposes requirements on existing permit holders, courts have consistently and carefully examined whether those requirements place an undue burden on people who already demonstrated their compliance under prior law. The seniors specifically, there is an additional layer of legal scrutiny that courts have applied, mandatory requalification requirements that involve physical and cognitive testing. Components have been examined for whether they create a discriminatory barrier for older Americans whose physical limitations have absolutely nothing to do with their ability to safely own and store a firearm. In several states, the legislature addressed this directly and proactively by writing age-based exemptions into the law before courts even had to weigh in. That is not charity. That is a legislature acknowledging that blanket requirements applied uniformly across age groups to create real disparate impact on older Americans, and choosing to address it legislatively rather than wait for litigation. Here is what you need to do with this information. You cannot assume your state has this exemption without verifying it yourself, specifically and directly. What I am telling you is that these exemptions exist across many states and that most people, including most seniors directly affected by them, do not know to look for them. Go to your state's official Attorney General website. Go to your state legislature's official legal code. Search your state's carry permit statute. You are looking for language that uses terms like exemption for permit holders over the age of 65, waiver of requalification requirements for senior permit holders, or grandfather permit status for long-term holders. If you do not know how to navigate those databases yourself, or if the language is unclear, call a gun rights attorney in your state, not the police department, not a gun store employee, a licensed attorney. Because the stakes of getting this wrong are not abstract. They are the difference between keeping or losing a right you have held for decades. And that is not a decision you make based on a casual phone call to someone who may not have the complete legal picture either. Now, the second protection, and this one comes from federal law, which means it applies everywhere, in every state, regardless of what the state legislature did or did not include in their new gun laws. The Americans with Disabilities Act prohibits discrimination against individuals with disabilities in programs, services, and activities provided by state and local governments. That is not gun law language. That is civil rights language, and it has direct, powerful application to what is happening to senior gun owners across this country right now. Many new state gun training mandates are government-run or government-approved programs. And a significant portion of senior gun owners have disabilities, mobility limitations, hearing impairments, visual impairments, chronic pain conditions that make compliance with standard training course requirements genuinely impossible or unreasonably burdensome. Under the ADA, those seniors are legally entitled to reasonable accommodations, not theoretically, not aspirationally, legally. Right now, what does a reasonable accommodation look like in this context? It means that if a state mandates a gun training course requiring physical range activities that a senior with a documented mobility condition cannot safely perform, that senior has a legal right to formally request an alternative format, an adapted training structure, a written examination in place of a range qualification, a certified home-based assessment by an instructor who comes to them. What the state cannot legally do is look at that senior's disability, acknowledge it, and then say the requirement stands. Regardless, under federal law, once a reasonable accommodation is properly requested, the state has an affirmative obligation to provide it or demonstrate why it is fundamentally impossible, not merely inconvenient, to do so. There is a meaningful legal difference between those two things, and it matters enormously. The ADA is a shield that most senior gun owners in this country have never once been told they can pick up and use. The reason they have not been told is not complicated. It is that nobody who covers gun law news thinks to ask the question, does federal disability law intersect with state gun training mandates? The answer is yes, clearly and directly, and that answer needs to reach the people who need it. Before we move on, let me say this directly. If you know a senior who owns a firearm legally and is facing new training requirements they physically cannot meet, share this with them today, not next week, today. Because the accommodation process has steps, it has documentation requirements, and it has timelines that need to be started before a permit lapses or a deadline passes. The window of opportunity to use this protection is not unlimited. And that brings me to the third protection, which is the one I see cause the most preventable damage, when people misunderstand it. The word grandfathered gets thrown around constantly in conversations about new laws, but most people have only a vague sense of what it means and, critically, a dangerously incomplete understanding of what it requires from them to stay protected. When a new gun law is passed, many of those laws include a grandfather clause. That clause says that people who are already in compliance with the prior law before the new law took effect maintain certain rights under the old rules, even as everything around them changes. For senior gun owners who have held valid permits for years or decades, that grandfather protection can be enormously powerful. It can mean that an entire new training mandate, a new requalification requirement, a new fee structure, none of it applies to them. Not because they are special, but because they were there first and the legislature built a protection around that continuity. So here is the practical example you need to understand. A state passes a new law requiring all carry permit holders to complete a 12-hour training course and requalify on a range before their next renewal. But the grandfather clause in that exact same law says that permit holders who have maintained continuous valid permit status for 10 or more years are exempt from the training requirement and need only complete standard renewal paperwork. A woman who has held her permit for 22 years falls directly under that clause. She owes nothing to the new training requirement. Nothing. That is the protection as it exists. But here is where people destroy their own protection without realizing it. And I cannot stress this strongly enough. A grandfather clause protects what you already have. The moment you let your permit lapse, not revoke, not surrender. Just allow it to expire for 30 days because you were confused about the new requirements and were waiting to figure things out. So you may step outside the protection of that grandfather clause entirely. When you go back to renew, you may now be treated as a new applicant under the new law, subject to every requirement the grandfather clause was protecting you from. The continuity is the protection. The continuity is the whole point. And this means that the single most urgent, most practically important action any senior gun owner can take right now, regardless of everything else in this video, regardless of every other question they have, is this: do not let your permit expire. Even if you are confused, even if you are not sure what the new law requires of you, even if you are genuinely undecided about whether you want to keep the permit active while you figure it out. Renew first, get clarity second, because the sequence matters. It matters legally and it matters permanently. You can always decide not to carry after you renew. You cannot always undo the legal consequences of letting the permit lapse before you understood what it was protecting you from. This is not complicated once you hear it, but the number of seniors who have walked into the exact trap I just described, confused by new law coverage, waiting to clarify, accidentally letting their permits lapse, losing their grandfather protection, is not small, and nobody in mainstream gun law coverage is warning them. Here's another confusion that drives me absolutely crazy because it is so easily corrected, and yet it keeps happening. When people hear about new carrying laws, new permit requirements, new mandatory training, new restrictions on where you can carry in public, they sometimes conclude that if they cannot comply with or do not want to deal with the new carrying requirements, they must give up their firearm entirely. As if the two things are the same, right? As if losing the ability to carry publicly is the same as losing the right to have a firearm in your own home. They are not the same, right? They are not even close to the same legal question. The Supreme Court was explicit about this. Your right to keep a firearm in your home for self-defense is a fundamental constitutional right that does not depend on any permit, any training certification, or any carrying law. A new carry permit requirement affects your right to take that firearm outside your home. It does not reach inside your front door. A new training mandate may affect whether you can renew your carry permit. It does not require you to surrender a legally owned firearm sitting in your own bedroom. Those are two entirely different legal universes, and conflating them costs people their home protection rights every single other day. Think about Dorothy again. She does not walk around a mall or a parking lot with a holstered weapon. She keeps her firearm in her nightstand because she lives alone on a rural road and she wants to be able to protect herself. If someone comes through her door in the middle of the night, her right to that firearm in that nightstand is protected by the Constitution of the United States. It is not touched by new carry permit laws. It is not affected by mandatory range qualification requirements. It sits outside the reach of every new carrying restriction that any state legislature has passed in the last several years. No new carrying law touches it. None. And yet she almost gave that firearm up because the coverage of those new laws created the impression that they reached everything: her permit, her carrying rights, and her home protection all at once. They did not. They never did. And when someone tells a senior woman living alone that she has to give up a gun that stands between her and whoever might come through that door at night, based on a misunderstanding of what the law actually says, and that woman complies because she trusts the person telling her, that is a failure of information with consequences that are not abstract. They are personal, they are physical, and in the worst case, they are irreversible. Now let us talk about money, because this is the barrier that gets the least attention and affects some of the most vulnerable senior gun owners the most directly. New permit requirements almost always come bundled with new fees: application fees, training fees, range qualification fees, renewal fees. And for seniors living on fixed incomes, Social Security, pension, limited savings, the cumulative financial burden of those fees is a real documented barrier to maintaining legal gun rights. What most people do not know is that many states have built financial hardship waiver provisions directly into their permit fee structures. These waivers allow applicants who can demonstrate financial hardship through documentation of fixed income status, Social Security income, or income below a threshold to have permit fees reduced or eliminated entirely. This is not a handout. This is a legally recognized mechanism specifically designed to prevent financial barriers from stripping low-income Americans of constitutional rights, and courts have backed this. Courts have recognized that if a constitutional right can only be exercised by people who can afford a fee, the fee itself becomes an unconstitutional barrier. That argument is not fringe. It has succeeded in litigation. Here is how you access this protection. When you apply for a permit renewal, specifically ask the permitting authority in writing whether a financial hardship waiver is available. Ask for the process. Ask for the documentation requirements. Then gather your evidence, your most recent tax return, your Social Security income statement, any relevant financial documentation that demonstrates fixed/income status, then submit the waiver request formally as part of your application. If your state does not have an explicit waiver process and you believe the fee structure creates an unconstitutional barrier for you specifically, that is a conversation for a gun rights attorney who can evaluate whether your situation supports a constitutional challenge to the fee as applied. And that challenge has won in court before. It can win again. Your right to keep and bear arms does not have a price tag attached to it that only wealthier Americans can afford to pay. If you are being priced out of a constitutional right, there is a legal process to fight that, and you deserve to know it exists. The final protection I want to walk through is the one that matters most in the moment. When someone in authority looks you in the face and tells you something that is wrong, and it happens with real frequency. An officer at a traffic stop tells a senior gun owner that her permit is no longer valid under the new law. A clerk at a government office tells a senior that he needs to re-register his home firearm under new requirements that do not actually exist. A well-meaning but legally uninformed adult child tells their elderly parent that the new rules mean the gun has to go. None of these people are necessarily lying. Some of them genuinely, completely believe what they are saying. But belief is not law. And in the space between what someone in authority tells a senior gun owner and what the law actually says, firearms get surrendered that should never have left those homes, and they are almost never coming back. Here is the protocol you follow when someone tells you your gun rights have changed or been eliminated under a new law. You do not surrender your firearm on the spot, not to a police officer who claims your permit is invalid. Not based on a phone call from a government office, not based on anything short of a court order signed by a judge. Your firearm is your legal property. Voluntarily surrendering it is a decision you may not be able to undo. and you are not required to make it on the spot under social pressure from someone who may be working from incomplete information. You write down everything. You note who told you what, when, what specific law or requirement they cited, what exact language they used. The more specific your notes, the more useful they are to an attorney. You contact a gun rights attorney, not tomorrow, today, because even when there is a legitimate legal question about your permit or your firearm, there is almost always a process available to you. An appeal, a waiver request, a correction of a clerical or administrative error. An attorney can navigate those processes on your behalf, but those processes have deadlines. And voluntarily surrendering your firearm before you understand your options can permanently eliminate some of them. You contact your state's attorney general office or a gun rights organization in your state. Organizations like the Second Amendment Foundation and state-level gun rights groups have legal resources specifically built for exactly this scenario: gun owners facing incorrect or aggressive enforcement of new laws who need help fast. The people who have been quietly counting on senior gun owners not knowing their rights, counting on confusion, counting on deference to authority, counting on the natural human instinct of an older American who does not want trouble. Those people have been winning by default. They have been winning not because the law is on their side. They have been winning because information is power, and the information has not been reaching the people who needed it. Most Dorothy kept her gun. Not because someone bent the rules, and not because she got special treatment, and because she found out what the law actually said, and the law was on her side. It was on her side the whole time. The exemption existed, the protection was there, the constitutional right was intact. All that was missing was the information. That is what this is about. If there is a senior in your life, a parent, a grandparent, an aunt or uncle, a neighbor down the road who legally owns a firearm and is confused or scared about new laws right now, share this with them, not next week, today. Before they make a phone call to a permitting authority they do not fully trust, before they listen to a family member who means well but does not have the legal picture, before they make a decision based on incomplete information that they will not be able to walk back. The people who need this most are not searching for it. They are trusting the wrong sources. They may be one conversation away from surrendering a right they have held for 30 years based on something that simply is not true. And if this channel is doing what it is supposed to do, if this is the kind of reporting you believe people deserve, subscribe right now. Hit the notification bell and leave a comment below telling me what state you are in, because the more I hear from the people watching, the more specifically and directly I can report on the laws that affect them. The law protects Dorothy. It protects thousands of seniors across this country who have never been told what protections exist for them. The age-based permit exemption means many seniors do not need to re-qualify under new laws, but you must verify your state's specific statutory language. The ADA accommodation right means mandatory training requirements cannot be legally applied to seniors with qualifying disabilities without reasonable accommodation, and that federal protection operates in every single state. The grandfather clause means continuous permit holders are shielded from new requirements, but only as long as they keep their permits active, which means renewing before confusion becomes a lapse. The constitutional separation between home storage rights and carry rights means no new carrying law reaches the firearm in your nightstand, not one. Financial hardship waivers mean permit fees cannot legally become a barrier to a constitutional right for seniors on fixed incomes, and courts have repeatedly affirmed that principle. And when law enforcement or government employees or well-meaning family members get it wrong, and they do, the protocol is clear: do not surrender, document everything, contact an attorney, and contact a gun rights organization that exists specifically to help in that moment. These rights are real. They are established. They are in the legal code right now, and the only reason they are not reaching the people who need them most is that nobody with a platform has been doing the work of making that information accessible, repeatable, and impossible to ignore. That ends here. You know your rights now. Make sure the people you love know theirs too.